Before you sign any will, I need you to listen to these 5 rules. They are not suggestions. They are what separates a document that will hold up in court from a document that will fall apart at the first challenge. I watched both outcomes hundreds of times from my seat on the bench, and the only difference between them, in the overwhelming majority of cases, was whether the testator knew or did not know what I am about to tell you now. My name is James Harlow. For 28 years, I sat as a probate court judge, presiding over estate, guardianship, and elder abuse matters at the trial court level. I read the petitions, heard the testimony, signed the orders. I ruled on thousands of contested wills, undue influence claims, and capacity challenges. And in all those years, what I observed was one consistent truth. The law arrives only after the damage is already irreversible. The deed has been signed. The account has been emptied. The power of attorney has been used. By the time the case reached my courtroom, all that was left to do was to record the loss. I retired at 64, not because the bench had stopped suiting me, but because I had come to understand that issuing a ruling is too late. The only useful thing I can do now is speak before the signature, before the mistake, before the loss. When I was on the bench, I could not discuss cases publicly. A judge does not give interviews. A judge does not publish analysis. A judge issues opinions and moves on to the next docket. Retired, I am free to use what I observed in 3 decades for a purpose I consider higher than judgment. I can use it to prevent the next one. Today I am here to give you 5 rules, not 5 suggestions, 5 absolute rules that state probate law, consolidated case authority, and 3 decades of my experience confirm, one by one. If you follow all 5, your will is going to produce its intended effect. If you break a single one, you are betting against the statistics. Rule number 1. Have your will drafted and executed by a licensed estate attorney in your state, in the form your state requires, with a self-proving affidavit attached. Do not download an online template. Fill it out at your kitchen table and assume it is enough. Most American states recognize 3 categories of wills. The attested will, signed by the testator and witnessed by 2 competent witnesses in most jurisdictions, 3 in a few. The holographic will, written entirely in the testator's own handwriting, recognized in roughly half of the states and invalid in the rest. And the nuncupative will, an oral will, allowed only in extremely limited circumstances. Each form has precise requirements, and missing one element invalidates the entire document. I will tell you the case of Mr. Marvin Caldwell, 79 years old, retired textile manufacturer in a mid-sized town in the Carolinas. His estate consisted of a paid-off home and approximately $140,000 in retirement savings. He went online, found a $50 will template, downloaded it, filled it out at his kitchen table, signed it, asked one neighbor to witness, and put the document in his desk drawer. He believed he had handled his estate. When Mr. Caldwell passed 5 years later, his older daughter brought the document to her brother's attorney. The attorney opened the file and saw the problem immediately. North Carolina, like most states, requires 2 witnesses for an attested will. There was only one. The will was thrown out. The estate passed under intestate succession laws, in equal shares between the 2 children. The intent Mr. Caldwell wrote out, signed, and dated carried no legal weight whatsoever. And I will give you a second case to drive the point home. Mrs. Marjorie Tilden, 78 years old, executed a perfectly proper attested will in 2014 with 3 competent witnesses, all properly identified. When she passed in 2022, 8 years later, 2 of the 3 witnesses had died, and the third had moved out of the country and could not be located within the procedural deadlines. without a self-proving affidavit attached to the original document. The probate court required the witnesses to be located, alive, and available to testify in person. The estate spent 14 months trying to locate the third witness through international service. By the time she finally responded, two distant nephews had filed a contest seeking to invoke intestate distribution. The complication cost the heirs roughly 7 years of probate proceedings and approximately $180,000 in attorney fees, court costs, and expert witness fees. The will was eventually admitted, but the time lost during the litigation devoured the estate. The principal residence, with no maintenance and no use during the proceedings, lost approximately 30% of its market value. Property taxes accumulated. Frozen accounts produced no return. That is the invisible cost of poor execution. Even when the will survives, the time of litigation destroys what it was supposed to protect. A self-proving affidavit, attached at the moment of execution, eliminates the need to locate witnesses after death. It costs nothing additional. It saves everything. Rule number 2. Go to the attorney's office alone, without any child, grandchild, niece, caregiver, or any person who may appear as a beneficiary in the will. A will is a personal act. The intent must be free. When a beneficiary accompanies the testator, picks the law firm, retains the attorney, schedules the appointment, drives the testator to the office, and stays in the room during the drafting, the law calls this undue influence. Undue influence voids the will, or the dispositions tainted by it, even when the testator's intent was genuine. I presided over the case of Mrs. Catherine Vincent, 75 years old, 3 children. She was driven to the law office by the daughter who hosted her. The daughter recommended the firm, contacted the attorney, sat next to her mother during the entire drafting session, signed in the room as witness. Everything was cordial, no visible pressure, no threat. The will heavily favored that daughter. The other 2 children contested. The case came to my courtroom. The record showed everything. The daughter had paid the attorney's retainer. The daughter had scheduled the meeting. The daughter had driven her mother to the office. The daughter had served as a witness on the document. I set aside the will. The estate passed under intestate succession in 3 equal shares. The daughter who had been caring for her mother received the same share as the siblings who had not. Not because of bad faith on her part, because of excessive presence. And here I want to clarify a point that many people do not understand. Undue influence does not require bad intent. I have seen wills set aside where the favored child sincerely believed they were helping their mother, with no manipulative intention whatsoever. The law does not ask about your intention. The law asks about the objective context. And when the context shows that the beneficiary controlled the process, undue influence is presumed. I also saw the opposite case. Mrs. Estelle Brennan, 72 years old, wanted to leave the larger share of her estate to the granddaughter who was caring for her. She was guided by an external attorney chosen without family input. She went to the law office alone, in 3 separate visits. She attached to the will a handwritten letter explaining her reasoning, video declarations of intent, and a recent psychological evaluation attesting to full capacity. When she passed, 2 children contested. The litigation lasted only 11 months. There were no markers of undue influence. The granddaughter had no involvement in the logistics. The witnesses were attorneys from the firm who had no connection to anyone. The court rejected the contest. The will was upheld in full. The difference between the case of Mrs. Vincent and the case of Mrs. Brennan was not the intent. Both wanted to favor the person who was caring for them. The difference was the context surrounding the signature. That context is everything. Rule number 3. Make the will while you are healthy and demonstrably competent. Do not wait for the hospitalization, the stroke, the dementia diagnosis, or the medication regimen that compromises judgment. State probate law requires testamentary capacity at the moment of execution. The testator must understand the nature and extent of the property, the natural objects of the bounty, and the disposition being made. When that capacity is in doubt, the will is set aside. And doubt is easy to plant when the document was executed in a hospital setting, under opioids, under anti-anxiety medication, or in already recognized late-stage cognitive decline. The case of Mr. Adrian Foster illustrates this clearly. 81 years old, admitted to a geriatric facility for the management of advanced dementia complications, on a continuous regimen of 5 psychiatric medications for nighttime agitation. The oldest son arranged for a will to be executed during the admission, with a notary public dispatched to the facility. 2 years later, in the will contest brought by the other heirs, the medical records showed that 3 of the 5 medications administered during that week, according to standard pharmacology references, are known to compromise cognitive function in patients over 80. A court-appointed medical expert concluded that capacity at the time of execution could not be reliably established. The will was thrown out. Here is the point. Even if Mr. Foster had been fully lucid at that moment, the context recorded in the medical chart made it impossible to prove afterward. The rule is straightforward. Execute your will at 65, at 70, at 75, not at 82 when you are already in a facility. Along with the document, request a recent letter from a licensed physician documenting full testamentary capacity, dated within 30 days of execution. I will be even more specific. The letter should be issued by a primary care physician or a geriatrician in good standing with the state medical board, describing the patient's cognitive state in objective clinical terms. It should mention that the patient was assessed using instruments such as the mini mental state examination or its equivalent, and obtained a score consistent with full capacity. It should be dated, signed, and on letterhead. That document, attached to a properly executed will, is essentially impenetrable in court. I have seen contested probate proceedings dismissed at the trial level and affirmed on appeal solely because of that letter attached to the file. It costs between $100 and $300 to obtain. It saves millions in estate value and years of litigation. I am going to pause for a moment. If you are still here, this subject matters to you or to someone in your family. Do one thing. Subscribe to the channel and leave a comment with the word "received." That gesture helps deliver this video to other families who need these rules before they sign anything. Back to the 4th rule. Rule number 4. Personally verify who serves as witness on your will. The witness cannot be a beneficiary, the spouse of a beneficiary, or in many states a close relative of a beneficiary. They must be entirely independent, with no emotional, family, or financial connection to any disposition in the document. In most American jurisdictions, there is a rule called the interested witness rule. When a witness is also a beneficiary, the consequence in many states is what is called purging. The gift to that beneficiary is voided. The will may stand as to the rest, but the disposition to that specific person is purged. And it is usually the most valuable disposition in the document. Mrs. Adele Burton, 73 years old, executed a will in Atlanta, Georgia. She brought as a witness a man who had been introduced by the very nephew she was favoring in the will. The man was the nephew's closest friend. When the will was contested, that connection was discovered. The court applied the interested witness rule directly. The disposition in favor of the nephew was purged. The commercial property he was supposed to inherit fell into the residuary estate and was divided among the other heirs. The nephew received nothing, even though his aunt's intent was perfectly clear. And let me expand. State law also bars certain other witnesses, including in some states the notary public who notarized the document, employees of the law firm that drafted it, and individuals lacking legal capacity themselves. The list is technical, and most people, including some less experienced attorneys, are not fully aware of every category. I saw a case roughly 6 years ago in which a will was set aside because the second witness, while apparently independent, was the second cousin of one of the named beneficiaries. The familial relationship had to be proven by birth records, and it was. The court applied the prohibition. The disposition to that beneficiary was voided. He lost an inheritance valued at approximately $400,000 because of a witness he did not select, but who happened to be in the room. That is why I insist on this. Verifying the witnesses is not the law firm's responsibility. It is yours. You need to know, before you sign, who those people are and what their relationship is to each beneficiary in your will. Rule number 5. Update everything after every major life event. Divorce, remarriage, the birth of a child, the death of a named beneficiary, the sale of a major asset. Update the will. Update every beneficiary designation on every life insurance policy, every retirement account, every payable on death bank account. The beneficiary designation overrides the will, always. In most American states, getting married, getting divorced, having a child, or losing a major beneficiary creates immediate legal consequences for an existing will. Some states automatically revoke a bequest to a former spouse upon divorce. Others do not. Some grant a pretermitted spouse claim if a marriage occurred after the will was signed. Others do not. The rules vary state by state and apply to some assets but not others. The most important thing to understand is that a substantial portion of the typical American estate does not pass through the will at all. Retirement accounts, life insurance policies, and accounts with named beneficiaries pass directly to the named beneficiary on file with the institution. Those designations almost never get updated after divorce. I followed the case of Mr. Theodore Sutton, 73 years old at the time of his death, retired engineer, married a second time to Mrs. Henrietta since 2018. Mr. Sutton had previously been married to Mrs. Margaret. They had been together 32 years. They had 2 children. In 2008, at 58 years old, Theodore and Margaret executed reciprocal wills, signed at separate sessions with the same firm. Each will left everything to the surviving spouse, with the children as remainder beneficiaries. They had also named each other as the primary beneficiary on the life insurance policies and the retirement accounts. In 2014, the marriage ended. Amicable divorce, property settlement signed. Each went their own way. In 2018, Mr. Sutton married Mrs. Henrietta. They built a life together in Texas. He never updated his will. He never updated the life insurance beneficiary form. He never updated the retirement account designation. He believed the divorce had handled everything automatically. In 2023, Mr. Sutton died unexpectedly. And here is the surprise that devastated 2 families. State law revoked the bequest to the ex-spouse under the will, so Mrs. Margaret did not inherit through probate. Good. But the life insurance policy, governed by federal ERISA rules for the employer plan, paid out to the named beneficiary on file at the date of death. That beneficiary was still Mrs. Margaret, the ex-wife. Hundreds of thousands of dollars went to her, not to Mrs. Henrietta, and not to the children. The retirement accounts paid out the same way. Mrs. Henrietta received the spousal share of the home and the probate assets that did pass through the will. The children of the first marriage received their share of those probate assets. But the largest single asset of the estate, the life insurance, went to a person who had not been part of Mr. Sutton's life for 9 years. Every one of those beneficiary designations could have been updated in 15 minutes with one phone call to each institution. Mr. Sutton had 9 years between the divorce and his death. Nobody told him beneficiary designations override the will. He believed the document in the desk drawer was the controlling instrument. It was not. I'm going to leave one final technical observation before closing. In the United States, having a comprehensive estate plan drafted by a licensed estate attorney typically costs between $500 and $3,000, depending on complexity. A contested probate matter, litigated through the appellate stage, can cost a family between $50,000 and $300,000 in legal fees and take 3 to 7 years to resolve. The math is simple. You pay the estate attorney now, or you pay the probate court later, usually with the family's piece as the additional cost. I want to add an observation that not every attorney makes clearly. A will is not an instrument for the wealthy. It is an instrument for any person with assets, with any non-trivial family structure, and with any concern about what happens to the people who remain. I have set aside wills involving estates worth $80,000 that destroyed sibling relationships of 50 years. And I have seen families with multi-million-dollar estates pass through probate in peace because the documents were properly executed. The dollar amount at stake is not proportional to the suffering generated by the mistake. The suffering is a function of how much the family expected to inherit peacefully and discovered, after the burial, that they would have to litigate for what should have been obvious. That breach of expectation, that transformation of grief into a cold legal war, is what most corrodes the family fabric. And it is what these 5 rules exist to prevent. I will recap the 5 rules. 1. Properly drafted attested will from a licensed estate attorney in your state, with a self-proving affidavit attached. Always. 2. Go to the attorney's office alone. No beneficiary involved in the logistics. 3. Do it while you are healthy, with a recent physician's letter attached. 4. Verify the witnesses personally. No connection to any beneficiary. 5. Update everything after every major life event, including beneficiary designations. 5 rules. 5 minutes to write down. A lifetime for your family to thank you for. I know that many people will watch this video and think they have time, that they will handle it next year, that they need to first decide how to divide things, or talk to a particular relative, or wait until retirement, or get the financial situation organized first. I have heard every one of those justifications. I have also seen the consequences of each. The rule that comes before the 5 is to not postpone. The will that exists, even imperfect, can still be revised. The will that does not exist is an empty space that the law will fill for you, and the way the law fills it rarely matches what you would have chosen. 28 years on the bench taught me that a poorly executed document is the most predictable source of family tragedy in America. More than illness, more than accident, more than financial crisis. The poorly executed document is the only tragedy that depended entirely on a decision the testator could have made during his lifetime, with adequate time, and that most people postpone until it is no longer possible. I performed a mental exercise in my final years on the bench. I looked at the cases on my docket and tried to estimate how many would have been avoided if the testator, at some point in their active life, had executed a properly drafted will with the 5 rules I just described. The answer was above 80%. 8 out of every 10 disputes that consumed years of American probate court time could have been prevented by an afternoon at an attorney's office, 10 or 15 years before the death. That number is what motivated me to speak publicly. If a fraction of that 80% can be converted into properly executed wills because of a conversation like this one, the time I am spending here will have been the most useful of my 28 years. If you listened all the way through, I thank you for your time. Share this video with someone in your family who has not yet drafted a will, or who drafted one years ago and never reviewed it. It might prevent a fight that lasts years in probate court. And if you have a story about a will that caused conflict in your family, write it in the comments. I read all of them. Each story helps me better understand where the system is still failing and which families most need to hear this conversation. Take care of yourselves and take care of the people you love.